My stack is so big, and I'm not getting to many important parts of it today, and I regret it. I regret it, and I'm going to have to complain to management that I need a third hour to get together with you, my listener, here at 92.7 David Tulis, and also at 95.3 HD4. Like us on Facebook. I would appreciate you doing that. Go to Facebook, Nooga Radio, and like our multimedia platform. We're also on YouTube. And my show is brought to you by Nooganomics.com, the website for the man who matters. I am the blogger with the biggest pen, bow tie, as I pretend to call myself. I'm not really, don't ever call myself that, but that is what some people in derision call the local economy guru, David Tulis. That's me. And I'm glad that you're giving me just a couple minutes of your time as we look at local economy and the free market here in Chattanooga and beyond, looking at the obstacles to free market. And we were hearing from Deborah Maddox, the community outreach coordinator for city government, about one of those obstacles, and that is the criminal record that people have. They have it from their own sinful acts in public, right, which are crimes. And some of them, as we read, are among those who plead guilty because they can't afford to miss work, they can't afford the cost. They're already in disarray in their personal lives, have many demands on them, not enough money, not enough sleep, not really enough food, and engine repair awaiting, and they just can't deal with it. So they plead guilty and end up to theft or something of that kind, or some misdemeanor. Get a job. They're trying to move on, improve themselves in the job market by employment, can't get a better job. They're just stuck. And that is because they pleaded guilty. And so there are obstacles that are state created. And the blight on your ID, right, the blight on your identity is a state blight. It comes from the state. Again, because sometimes because you've done a crime and you've had been held to account for that. But it is a blight that comes from the state itself against you and against people who could work for you. But you're not going to look at their applications because they checked the box and said, convicted of crime or served time in a jail or prison for a civil offense. One of the things that I'm looking at this week is the Miranda problem. Miranda is from an important case, Miranda versus Arizona, that came from the High Court in 1966 and provided for a decree. The courts don't make law, but they give opinions, and the opinions have effect of policy by requiring people who want to avoid the problem that raised in that case, avoid that problem by adhering to what the rulers say in their opinion. Right? It is just an opinion. It's not enforceable except by consent among the legal classes who have a great influence and sway in our day. And Miranda requires the police officer in Chattanooga to tell the arrestee that he's under arrest. First of all, that's the most important point. And then the other points are about the rights of the arrestee to not be required to incriminate himself, and that anything he says or produces in the way of documents or proofs or arguments or statements, whether written or oral, will be used against him as part of the state's evidence base in its accusation against him, right? Because in our modern jurisprudence, the state is always the offended party, and the state is always the accuser. So when you see a state actor, just view that person as a potential accuser of you in some area, whether it's environmental regulation or taxation or some control in your industry, or someone pretending control over your movement. That would be the officer on the street. Most people, if you're like me, have few encounters with the police, except in what's called traffic or transportation. They are enforcers for commercial government out of Nashville, and they enforce Title 55, the commercial use of the highway on everybody. Everybody is subjected to that. Most people, because they agree to that jurisdiction, which is administrative and in commerce in the area of transportation. And so police encounters between members of the public are common on that point. And many of them are unpleasant. Some are pleasant enough when the officer is in a jovial mood and not inclined to want to press his claims as he perhaps could against the arrestee. But Miranda, tells you, first of all, that you're under arrest. And what's been happening in Chattanooga for a long time, I'd like to suggest, is that police officers, like those in East Ridge and Red Bank and Saudi Daisy, I suspect, do not Mirandize like they are supposed to. Now, Chattanooga has a policy manual that has been a very, very interesting reading for me. There is OPS 42 arrest procedures, and I think it's on page 6 where the rule is given for Miranda. And you can read about that at Nooganomics.com. A story that came out a couple days ago is still my leading item. And it says that this rule to Mirandize gives alarm. All right, it does give alarm, and that's what it's supposed to. It's supposed to give alarm to the person who's arrested. Now, the question, I guess, comes up is, what is arrest? A police officer will go as long as he can to prevent you from knowing that you're under arrest, and he will engage you in a conversation for the purpose of eliciting material from your flapping gums that will be incriminating. All right, that is to say, that will make you look bad and give him cause to actually under arrest. Okay, or I have authority from what you said to search your car, or to search your person, or your bag, or your contents of your car, your briefcase, your trunk. I have authority based on what you said. That is probable cause. And since the standards have of government that control the government have been weakened, they have been lowered thanks to our Republicans and Democrats on the Supreme Court in Tennessee. There doesn't even have to have probable cause anymore, but there is articulable suspicion and reasonable suspicion. Get this: whenever the government in its claims about its necessities says it needs to have a reasonable standard for anything, be sure that will always be turning against you, the listener of the David Tulis Show here on 92.7. Reasonable is always in favor of the state, never, ever, ever in favor of the individual. And so the standard for your protection is continually being reduced. And Miranda was an effort by the court which wanted to allow for the police state to have some semblance of protection for the individual, because at the time, there were very abusive police interrogations. It used to be called the third degree. You got the third degree, that means that you were harassed, you were kind of browbeaten, and sometimes you were actually beaten by the police to elicit from you a confession or an admission that could be used in court. And that's the Miranda case sought to forbade that. And Miranda largely stands, though the summary of the current status quo is, if you look at Wikipedia, there is a discussion about cases that seem to nip away at some of the parts of the Miranda. For example, a spontaneous statement is allowed. You make a spontaneous statement about something that you did that's incriminating, apart from being involved in an interrogation or an inquiry by the officer, that can be used against you, right? Even though you've not been Mirandized. A spontaneous statement that you made, her body is behind the barn, that kind of thing, that is going to be allowed. This is David Tulis, and call, you're live on the air. What's on your mind?
David, I couldn't wait. When you talked about Miranda, it was like holding a steak bone in front of a dog salivating, and that's me. I am against giving the Miranda warning, okay? I don't think anyone should be required to do that because the Constitution doesn't demand it. That's number one. Number two, it's an excuse for the police to cunningly coerce you out of your constitutional rights. Now, I didn't make that up. That's a quote from the Supreme Court, and that's coming from somebody that's not anti-police. But the Supreme Court says that the police will cunningly coerce you out of your constitutional rights. Mr. Tulis, if you're just honest with me, this will go really well. Do you have any contraband in your car? So on and so forth. The Fourth Amendment does not change because the Supreme Court wants it to change. And the Supreme Court is not the final say. I want every lawyer, I want every judge to hear this. The Supreme Court is not the final say. The Constitution of the United States is the final say. When a lawyer says, well, it's going to be interpreted, no, it doesn't. The Supreme Court applies law and statutes and looked at the applicability of a particular statute. All of it are in part, and to determine whether it's not that statute falls within the constitutional realm, whether any or all of it's constitutional. So let's get that out of the way. As far as Miranda versus Arizona is concerned, The system believes, David Tulis, you can waive your rights. You can't. The system believes, David Tulis, you can plea bargain. You can't. With Miranda, what happens is the police will lie. They always lie on the stand. I covered trials. Mike Steele covered trials for years. They will lie to win. They will present witnesses to win. This goes beyond the police. So once you say, yeah, I understand my rights, and they cunningly coerce you to speak, they will use that against you. The Fifth and Fourth Amendments are there as a protection to ensure that government digs up the evidence. The founders wanted this, that they dig up the evidence to bring before an objective jury beyond a reasonable doubt to then find you guilty or not guilty.
And the founders wanted that to be done apart from the admissions of the...
Go ahead.
You're saying that the founders wanted the police to create the work, do the work to find proofs of guilt apart from admissions by the defendant.
Well, the founders didn't envision a police department, administrative police department. All police departments are unconstitutional. They're not allowed. The founders didn't envision that. They envisioned a militia. The sheriff's department is constitutional. There should be no police departments. They need to be morphed into the sheriff's department because we elect the sheriff. They're direct representatives of us. The police departments, all they do is enforce statute. They're not there to protect your individual constitutional rights. That's a whole other issue. But the point being is, if the court says, you know what, and I read Miranda several times. Miranda was a scumbag. He was a rapist. He was a thug. But the police beat a confession out of him. And what the court said was this, that if it's shown in this court that you beat a confession out of someone without first advising him of his rights to speak, we will throw that evidence out. And they also use the FBI as an excuse to do this because the FBI would say, you know what, Mr. Tulis, if you talk to us, you realize this evidence can be used against you. And then they went on to cunningly coerce you out of your constitutional rights. It's nothing more than another tool for the law enforcement growth industry.
Well, all right. So are you saying, Mike, that the Chattanooga Police Department should continue to not read Miranda rights? Is that what you're suggesting? Because my argument is that they should read Miranda rights the moment the person's arrested. Hold on, Mike. Let me finish. Mike, just let me finish. My argument is that since we have Miranda as an opinion that controls operations of sheriffs and police departments, since it does control, that it's wrong for any agency to not read those rights to a person who's under arrest. And the problem is that in not letting my listener know he's under arrest, the listener mistakenly has a conversation and things he admits in that conversation are used against him.
That's why the station's here. That's their stupidity. A wrong is a wrong. Let me give you an example. I had this debate the other day with the idea of the police officer upholding the right of an abortion clinic to murder unborn children. And my next question was this. What if the Supreme Court ruled it's okay to murder your child after it's born up into a year? And there were clinics where you march your kid in up until they're a year old and they execute them, they euthanize them. Would you as a police officer stand by because the Supreme Court said it so? Well, I hope not, and I would say no. So just as that is wrong, all illegal, unconstitutional decisions are wrong. The Supreme Court was wrong, and no one's obligated to follow it. There are many Supreme Court decisions that no one's obligated to follow because they're not lawful. The Constitution is the final say, not the Supreme Court.
Well, what happens to Miranda in this analysis, Mike?
Miranda goes away.
Miranda's a protection for my listener.
Is if the police don't obtain the evidence independently, that person gets set free. But see, the system doesn't want to do the work, David. They work 8 to 9 hours a day and get paid a lot of money to enforce their political will against you and me.
And they want to churn through the populace to have cases. They're churning through the populace to have cases.
And they want it even easier. See, they don't want to work. They don't want to have to dig this stuff up. They want you to admit it. And even if you didn't do it, they want to get you on something. You know, we're going to charge you with resisting arrest. Well, how can one be charged with resisting arrest if it's not another crime to follow that up? Disorderly conduct. It's the law enforcement growth industry. I want everyone to understand, if you haven't been in jail, you will someday, or a family member will, because it's the goal of the system. And they are the individuals elected and are hired to oversee and perpetuate the growth of fascist, Marxist, socialist, communist welfare state. They get everyone in the system one way or another.
Well, they have us in the system already through Social Security, Mike. Well, Mike, we're already in the system through Social Security. We're already all kind of wards of the state. We're all sort of federal property under the Department of Commerce through the birth certificate and other claims upon us through the corporate status. Why we're theorizing here, but why would you propose that on the topic of Miranda? I mean, they all want everybody to be in jail at least one. They want everybody to be booked at least once. Is that what you're saying?
Of course.
One booking is all they need.
Because once again, you have to come to permission for your master to give you permission, do or not do something.
Right. Well,
listen,
policing
the system requires three things of everyone: your time, your money, and your obedience. And that's the reason for checkpoints. They're not to get drunk drivers off the road. It's to ensure that you're going to be an obedient little sheep,
right?
And recognize there's an authority over you, which there isn't. There only is because you believe there is. God is the only authority over you. That's it. Unless you're not a Christian. If you're a Christian, then the government is your master. Bow down and kiss his feet or her feet.
Listen, Mike, thanks very much. I want to appreciate your call. But the point I want to get to about Miranda is this: there's a problem. There's a problem. Miranda is the rule. It's in the arrest procedures rule, but it's not in the motor vehicle stops rule. Okay, and we have the Coonrod arrest in, I think, July, widely publicized. Anthony Gladden and Mrs. City Council member Demetrius Coonrod, they were arrested. Okay, you're arrested, and I think I need to say what arrest is. Arrest is not simply when they put the handcuffs on behind you. That's what the police want you to think that's what an arrest is, but an arrest is when you're stopped. Okay, the word arrest means stop. And there are cases that, at least two cases I've read that make that very clear. State versus Garcia, that's 2003, and State versus Raspberry of 82. A stop equals an arrest equals a seizure. They're all the same things legally. So the moment the blue lights are on, here's the main point. Okay, the moment the blue lights are on, you are under arrest, and you should be Mirandized. If they're going to stop you on the highway, your free and innocent and harmless movement, probably as a private person, even though your car has a tag on it suggesting you're in commerce. You're a private person. If they're going to stop you, they had better have something on you to arrest you right then. We have in the statute, though, we have a procedure aside from arrest, and that is the citation procedure, which again is a convenience for the operation of the police state. It avoids the unpleasantness that would be hysterical and a mass unpleasantness if everybody had to be arrested for every alleged offense. What happens is the state gives you the easy way out. Sign the citation, appear in city court or sessions court, and try to dispose of your little problem there. They don't have to do what the law requires of an arrest, which is a booking, taking the man before the magistrate, bailing, booking, and release for trial. That's what has to happen in a criminal matter. What the state tries to get away with is to have these quasi-equitable, quasi-criminal jurisdiction where it's not quite clear if it's a crime or if it's a civil matter, right? Traffic is a civil matter, and yet it's being criminalized by commercial government. That's another point. But getting back to Miranda, you should be, the moment the lights are on, you should be Mirandized, because anything you say will be used against you. Anything you give or show the officer will be evidence against you in court. So if you're not in commerce, then don't give anything. Right? That's the position you should take if you understand that you're not in commerce but you're operating privately. But if you give your driver license, registration, proof of insurance, then you need to be sure to say nothing more than that, because anything you say can and will be used against you in court, which is what Miranda requires you to be told at the beginning. The officer doesn't like a sharp line, right? He wants there to be no clear line at all. He's already arrested you in his mind, right? He already has the articulable suspicion. But what he wants to do is for you to say more, right? He wants there to be a drug stop or a DUI stop. He wants to convert every stop into that if he can, because that's the most lucrative and that's the most interesting. That makes his life interesting. And it's not just this dreary safety talk with, moms with their children. She's at the window, they're at the car. That's kind of boring. The best is some kind of action. And he will try to escalate to that if he can. But don't give him the fuel. Don't give him the fuel. Don't give him the food, the nourishment for that line of thinking. He doesn't want you to know that you're under arrest. And so the Miranda rule in the department policy should be, if a person's arrested, he needs to be Mirandized on the spot. Hanson Melvin was not Mirandized in our coverage last year, and neither was Rochelle Gelpin, according to her statement to me. She was not read her Miranda rights, though I must say I did not specifically ask her that question, and I've not called her since then. They were both arrested, I think, in April of 2016, both falsely charged, falsely harassed by 2 officers, one of whom has been fired since then in the Hanson Melvin case. Miranda is required, and Miranda should not be short-shrifted, whatever the case. And I think part of the problem that the Miranda rule imposes upon David Roddy, the chief of police, is that it's kind of negative, right? To be Mirandized is to suddenly be told you need to have a lawyer. Don't talk without your lawyer present. If you do, anything you say will be used against you. That's a terrifying thing to hear. It's terrifying to hear that. It's bad marketing for city government. It's bad marketing for the mayor, Mayor Andy Burke. And it's bad marketing for David Roddy, who wants to have a communitarian approach to policing, if that's what you have to do. And yet Miranda requires this brusque, bristly, this Brillo pad kind of treatment of the member of the public. He has to be treated that way up front and immediately. And in fact, the arrest report, the arrest orders say that. They say that all these warnings must be given only before interrogation takes place. It is a good practice to give them immediately after arrest, okay? Right when you're stopped, immediately after arrest, okay? That's when you should get your Miranda warning, thereby making any offhand remarks or other voluntary comments by the offender admissible in court. That's what the rules say. That is Mayor Andy Burke's former chief, Fred Fletcher, in his report on arrest procedures under the CALEA standards, right? This meets the CALEA standards for openness, honesty, et cetera, et cetera. Mayor Burke has some work to do, and David Roddy has some work to do. They need to stop stopping people, and they need to Mirandize everybody who gets stopped. Everybody who's under arrest needs to be Mirandized without exception. The effect of that will be in your favor. You're my listener's favor. And the effect will be that there'll be fewer stops, fewer harassment encounters, fewer belligerent encounters by the officer as against you, the citizen. And don't forget, when the officer is stopping you, it's a belligerent, okay? It's belligerent. It's against you. It's not in your favor. It's for your harm. It's for justice, right? It's for the claims of the state against you. Those are always negative. I would say they're always negative, even though we have a welfare state that cares about everybody, loves everybody, wants to be everybody's mama. We have a state that's at war with the people, and the officer is the front line of that battle. It is social management. It is social control. It is kind of terrorizing the people, intimidating them, making them fearful, making them supplicant, making them cautious, not wanting them to invest too much in any of their own ideas, to be passive. I think policing is a very deleterious thing for people who once were free. We're not free now, and we're not free partly on account of policing in municipal corporations such as Chattanooga. Well, this is David Tulis. I really thank you for giving me just a moment of your time. We're brought to you by Nooganomics.com, and want you to subscribe to that. Also, like us on Facebook. We're live on TuneIn Radio. That's your radio app, an app which you have on your smartphone, and that you can hear all of our shows live. I do thank you for giving me just a couple minutes of your time. We argue for local economy and the free market, suggesting that you should love your neighbor and buy local. Near is better than far. Small is better than big. Simple than complex. Personal than corporate. And down in the footnotes, there's that last footnote, number 1. Physical is better than abstract. I do appreciate a couple minutes of your time here today. Do mind that we're radio, and you support David Tulis. You support Nooga Radio by patronizing our wonderful advertisers. Now, I've got Legal Bites next. Legal Bites next with Jim McCoon. Jim McCoon and Trevor Ashley, 2 great lawyers at the McCoon Law Firm. They have the best insights and some of the best materials that is helpful to you, my listener here at Nooga Radio.
The Tennessee Valley's news, talk, and sports leader.